This program is unique in the sense that for the first time, two events are being hosted by the Gavel and Gab Club. The first event is a book launch, and in connection with the book launch, we are having a debate of our junior members so that we are able to provide a platform to our junior members before honorable judges, before our senior members, and before guests. And why this debate of the juniors? The author of the book today was a judge of this very High Court, Justice Arun Kumar Das. He was a judge of our High Court in the 60s and retired in about 1968. Immediately after that, he had published a book called The Due Process of Law. For some reason or the other, due to vagaries of time, the book got lost from the Indian libraries and was restored and or recovered by his granddaughter almost about 40 years later in a library in the United States. And it is then she conceived the idea of reviving the book and reprinting it and making it public amongst the entire legal fraternity and the whole world. It is this effort of the granddaughter, Ms. Sonia Rai, that brought her in touch with one of our committee members. And the initial idea was to have a memorial debate. But then we were already thinking of this Gavel and Gab, where we wanted a platform for our junior members. Now, it is the culmination of these two ideas that resulted in today's event. Before I proceed further, I would first and foremost like to invite our chief guest, Justice Sujoy Paul, who has come to this library for the very first time. I stand corrected, for the second time. He had come at an earlier date also, but we were not there. So let us all welcome Justice Sujoy Paul, our chief guest, to this library. Sir, may I request you to please come and take the chair in the dais. May I invite on the dais our President, Mr. Sudipto Sarkar, and our Vice President, Mr. Utpal Bose. May I request one of my committee members, Ms. Shuchishmita Ghosh, to present a bouquet to Justice Sujoy Paul to welcome him in the Bar Library Club. Along with the bouquet, we have presented Justice Paul a small memento which was made during our 200-year celebration, and it is a token of our heartfelt gratitude for Justice Paul coming here and agreeing to be the chief guest of this occasion. A few words about Justice Arun Kumar Das, the author of the book that will be unveiled today. Justice Arun Kumar Das was born in 1908, educated at Calcutta University with masters and law degrees, served with distinction as a judge of the Calcutta High Court until his retirement in 1968. A man of clarity, scholarship, he continued to shape public thought through his writings on law and politics in the years that followed. He wrote extensively for the Statesman, the Bombay Times of India, the Telegraph, and was regularly invited by the Doordarshan for discussion and debates in the newsroom. His collected essays, published initially sometime in 1970s as the Due Process of Law, and its supplement, both of which are being revived and relaunched, reflect both depth of analysis and courage of conviction. They are also housed in some of the best libraries in and across the world, including universities of Columbia, Berkeley, and Cambridge. Copies of the books have also been requested by the United Nations at Geneva. The books examine the balance of power between Parliament and the judiciary, the scope of constituent authority, the need for constitutional reforms, and the perils of unbridled privilege and the enduring lessons of the emergency. We will get to know more of the book later. Now a few words about the second event today, which is Gavel and Gab. Most of you present here are aware as to what a gavel is. A gavel is the wooden hammer that the judge during British times used to use frequently to have orderly discipline and conduct in the court. Of course, in modern times, we don't find the gavel, but in a debate where we are going to hear adversarial views, it is necessary that an element of gavel is introduced to control the proceedings, which will be done by the chairman. I shall introduce the speakers later. And that is why we have coined this expression, Gavel and Gab, because lawyers are supposedly supposed to possess the gift of the gab, and that is how Gavel and Gab has been born. Now let us proceed for the very first event that all of us are gathered here for. But before we unveil the book, we are holding today's program under very sad circumstances, as we have lost one of our very senior members of the bar, Mr. Dastur, for whom all of us who were supposed to be present here, most of us who were supposed to be present here, had to leave, and we had an early rising of the court. May I request all of you, everyone present here, that we observe a minute's silence in the memory of Mr. Dastur. Sir, you can see. Thank you, everyone. You may take your seats. Ladies and gentlemen, we now proceed to the formal cutting of ribbon of the book, and I would request Justice Paul and our President and Vice President to kindly inaugurate. Before that, may I request the proud daughter of late Justice A.K. Das, Ms. Mridula Nandi, to please come up here on the dais and share the glory of her father and the book that her father had written. Please. Book by late Justice A.K. Das, Due Process of Law, relaunched and unveiled again a gap of nearly 4 decades. It's a proud moment for the family, a proud moment for our High Court, and ladies and gentlemen, we are fortunate that we all are witnessing this event, and all of you are here, notwithstanding the tough times we have faced for the entire day, where question marks were raised regarding whether we would be able to hold this program or not. Thank you, Justice Paul. Thank you, Mr. President. Thank you, Ms. Nandi. Now, since the book has been formally unveiled, may I request our President to hand over another copy of the book to Justice Paul such that that can be presented to the Judges' Library. We also have amongst us the representatives of our associate bar, that is the Incorporated Law Society and Bar Association. May I request Justice Paul to formally hand over a book to Mr. Paritosh Sinha, the Secretary of the Incorporated Law Society, with a request that the same may be placed in the library of the Incorporated Law Society. We have amongst us Mr. Dipanjan Dotto, the Assistant Secretary of the Bar Association. Sir, may I also request Justice Paul to hand over to Mr. Dipanjan Dotto such that the book finds a place in the library of the Bar Association. And of course, our President and Vice President is here, and since we are hosting the event, the book will definitely find place in the Bar Library Club, both upstairs and downstairs. The formal unveiling being done, a time for short speeches. Ordinarily, I would have first called upon Justice Sujoy Paul to say a few words, but he has made a request that he would make his speech at the last, after hearing the debate. And that is a great gesture and a signal to the junior members present here, and especially the speakers. So you are assured of Justice Paul's presence right till the end of the debate. That being the position, may I now invite our President, Mr. Sudipto Sarkar, to come and say a few words.
Good evening, ladies and gentlemen, my colleagues from the bar, Justice Paul, Honorable Dura, and other learned judges of this court. This is an outstanding event in many ways. Normally, we do not get to see so many new faces from the outside world in this dusty library that we have, although it's being cleaned up by Mr. Shobhashaji Chaudhary and his colleagues regularly. It's a very outstanding event because a lot of people, of course, are new. It's a new, probably they are new here as well, coming here for the first time. It's good that they have come. I think Joyantuda and I will remember Justice Das used to sit in court number 9 or number 10, say criminal matters when I first joined the bar. Of course, since I had nothing to do with the criminal law, I had no opportunity to interact with him. However, ladies and gentlemen, stay here, enjoy yourself. I have nothing more to say, no point wasting your time because the Gavel and Gab people are waiting anxiously to start their debate. So let me know. Thank you very much indeed.
The only other short speech that we will be having today is by one of our very senior-most members who had the occasion to appear before Justice Das, and for this may I invite Mr. Jayanta Kumar Mitro to come and say a few words.
Good evening, Justice Pal. Good evening, the learned judges. Good evening, my colleagues and friends. I have been suddenly asked to speak about Justice Ray, but I hardly remember. I think I appeared once or twice as junior to my senior, either Mr. Shankar Ghosh, I don't remember exactly, or Mr. Dipankar Ghosh. I remember in courtroom number 9 or courtroom number 10. The only memory that I have got of the learned judge after this long period of about 60 years is that he was a fine gentleman, very quiet, and unlike, if I may say so with the greatest of respect to the learned judges, unlike some of the senior judges who used to be, well, I should say, very strict with the juniors. This much I remember, that I was only the second junior who was sitting in the courtroom and assisting my learned senior at that point of time. And apart from a few questions which came from the bench, I don't remember exactly how the proceedings went on. Must have been 66 or so, when I was a 2 years toddler in the profession. My memory fails after these long years, but I remember a perfect gentleman as a judge on the bench, very quiet, very respectful to the bar, and particularly respectful to the juniors. I hold a very reverential memory of the learned judge, and I am very glad that his family members are present here to inaugurate a book which had been written long time back. In fact, from the oblivion, it has been restored, and we are very grateful to the members of his family. Thank you very much.
Thank you, Mr. Mitro. And before the debate begins, a few words from the members from the side of the family of Justice A.K. Das. May I invite Ms. Sonia Rai to say a few words about her grandfather.
Good afternoon. My throat has chosen to desert me on this very important day, unfortunately, for something called a Kolkata virus. But I think my grandfather's story will be louder than my voice. So please bear with me on this. Honorable judges of the Calcutta High Court, distinguished members of the bar, esteemed guests, dear friends and family, it is a profound honor to welcome you all today on behalf of Justice Das's family. Your presence here, despite the many demands on your time, lends this occasion both its dignity and meaning, and for that I am very grateful. It is indeed a moment of immense significance to stand here today in this august Bar Library Club at the launch of the book, The Due Process of Law, authored by my grandfather, the late Justice Arun Kumar Das, a judge who served in this very court and whose life and work continue to shape how many of us in the family understand dignity, fairness, and justice. Justice Das served as a judge of the Calcutta High Court in the late 1960s. Known for his clarity of thought and deep integrity, he is said to have interpreted the Constitution with both scholarship and humanity, seeing the law not just as a symbol of authority, but as a compass of fairness, a measure of conscience as much as of statute. Though this book, The Due Process of Law, was first published in 1980, some of its concerns resonate very keenly even today. In this age of restless public discourse and relentless social media noise, the book harks back to the dignity of restraint, to letting the voice of law speak for itself without being drowned by the collective social clamor of either trending or hashtag. That very voice has traveled far and wide. It gives me immense pleasure to say that this book is housed in the university libraries of Harvard, Columbia, Cornell, Berkeley, Duke, Michigan, Texas, Washington, Pennsylvania, Virginia, Chicago, and the US Library of Congress. It is also present in the universities of Oxford and Cambridge, in Berlin University, and the Peace Palace Library at The Hague, Netherlands, serving both the International Court of Justice and the Permanent Court of Arbitration. Copies have been requested by NUS Singapore and the National Law Schools in India. All this is testament to its quiet yet enduring appeal. But all that aside, it is in its return to the Calcutta High Court today, where Justice Das's legal journey was most deeply forged and rooted, that the book finds its truest and most symbolic homecoming. As a judge, my grandfather was more than the sum and substance of his robe and rulings. He, like so many of the honorable judges present here today, bore the weight of his decisions, sometimes especially at those fragile crossroads where the tenet of law touched the very sanctity of life. I am told on one occasion, after pronouncing capital punishment, he appeared pensive and heavy-hearted. When prodded, he did not explain himself. He merely invoked a passage from Tagore's Gandharir Obhishap, which goes thus: Dondite shathe dondo data, kade jobe shoman aghate, shorbo sreshto she bichar. Translated, when the dispenser of punishment feels the blow of the punished and shares in that sorrow, the highest form of justice has been served. On a lighter note, beyond the gravitas of the judge and jurist, to my sister and me, Justice Das was simply our grandfather, someone we affectionately called Dada. He took us out on walks, read to us, and yes, shielded us from many a parental storm. When once, as a young teen, I had tried to negotiate staying up later than usual, he had dismissed it firmly as an appeal without merit. Still later, when I told him I was intending to get married, he had quipped whether I was aware that I was signing up for lifelong hearings and arguments, albeit hopefully, he added, with the same opposing counsel. Justice Das would often say, the law may rest on precedent, but a good life rests on presence. He may no longer be with us in that physical presence, but his legacy endures in the pages of his book. My deepest thanks once again to the Bar Library Club and the Honorable High Court of Calcutta for bringing back the book, The Due Process of Law, into the very courtrooms and conversations that shaped Justice Das and those that he in turn devoted himself to serve with utmost fidelity and integrity. Today's homecoming, ladies and gentlemen, is all about law and legacy, memory and meaning, remembrance and renewal. Thank you.
Thank you, Ms. Rai, for the excellent summing up of the grandfatherly memories. Now, ladies and gentlemen, we proceed to the second half of our event, that is the debate. And before we begin the debate, may I just inform the House that the family of Justice Das has also made arrangements for refreshments. This time it's a buffet system. So what we will do is that as and when the debate proceeds, our committee members will first invite members of the family and guests, and in batches of 10 we'll just go to the adjoining room, collect our food and come back here and listen to the debate, so that we don't disrupt the debate, and at the same time, if we have the food at the end, then it will be too crowded. The room is not big enough to host all of us here. So we'll do that smoothly, don't worry. This is just the information. The food is ready and we'll guide you. Now, Gavel and Gab. The young lawyers who would be wielding the gavel and would be exhibiting here in front of us their gift of the gab are Mr. Ishan Shah, Mr. Porush Bandopadhyay and Ms. Amani Kayan. Can you just stand up and identify yourself? Mr. Ishan Shah, Mr. Porush Bandopadhyay and Ms. Amani Kayan. This team would speak for the motion, and I will soon introduce what the motion is. So they are the propounders. A big hand for them, please. And opposing and playing the important role of the opposition, the leader is Ms. Ujjoini Chatterjee, Ms. Sushreya Mitro, followed thereby by Ms. Sushreya Mitro, and last but not the least, Mr. Shourudip Banerjee. Ladies and gentlemen, the opposition. And in this tussle of the opposition and proposition, the audience today, after the end of the debate, by show of hands, would decide whether the motion is carried forward or it fails. And wielding the gavel today is the chairman and moderator of today's debate, Mr. Shayok Chakraborty, a well-known debater in the present public speaking Calcutta circuit. We have Mr. Chakraborty, and I will be soon handing over the proceedings to Mr. Chakraborty. And we also have a timekeeper. Mr. Chakraborty will, of course, tell the rules of the debate and how he wishes to conduct the same, and playing a very vital role so as to keep the time and ensure that the debaters don't exceed the specified time limit, which is a time limit of 4+1 minutes. We have Ms. Sriporna Mitro, who has this little bell, and the bell will toll after 4th minute once, and after the 5th minute twice or thrice, and that should be sufficient indication to the speakers to wind up. Otherwise, it will toll incessantly. Yes, the last and the best is reserved. So the proposition and opposition is going to fight for the proposition or motion, which goes like this. This House believes that due process of law is inadequate to meet the challenges of the digital times. I repeat, this House believes that due process of law is inadequate to meet the challenges of digital times. So, ladies and gentlemen, be prepared to hear an engrossing debate about due process, undue delay, so on and so forth. And for the further proceedings, may I hand over the microphone, or rather the microphone is already there. Oh, sorry, I just hand over to you. The microphone to the moderator of today's debate, Mr. Shayuk Chakraborty.
Hello. Thank you, Mr. Secretary, sir. And thank you all for attending this debate. It is always a good occasion to be in Bar Library Club for events like this, and I'm glad that a debate is what has brought us together today. Due process of law is undoubtedly the hot topic today, and it is indeed very interesting to see how it would be very interesting to see how the speakers interpret the notion of due process of law. Due process of law was something greatly feared by our framers of the Constitution, who feared that the wide-ranging notion of due process of law would lead to overindulgence of the judiciary and overpowering the judiciary at the expense of the executive. And thus they used the words procedure established by law in Article 21 instead of due process of law. But here we are going to debate on whether due process of law is enough to meet the challenges of the digital times, which is something undoubtedly the Constituent Assembly did not really consider, had no reason to consider at the time of framing of the Constitution itself. Regardless, the speakers are given 4+1 minutes to make their points. We are speaking in a parliamentary style debate, which in today's country we would mean that the parliamentary style of debate is one in which you behave exactly the opposite of what Parliament behaves these days, in the sense that you attack the ideas of the other speakers, not their individual persons, and that you conduct yourselves as gentlemen, unlike what Parliament acts today. So, with these words of caution, I must tell you that you will be given a warning bell by the timekeeper at 4 minutes, and then at 5 minutes, and if you continue to speak thereafter, you shall be most rudely interjected by myself. And if it continues so, you might be dragged off the podium to allow others to have the say. Regardless, we start off with the first speaker for the motion, Ishan Saha, who shall present his arguments. Ishan?
Honorable judges, my learned friends, ladies and gentlemen, the motion today reads, to start again. Honorable judges, my learned friends, and ladies and gentlemen, the motion today reads, due process of law is inadequate to meet the challenges of the digital times. Since I am mostly among my seniors and peers today, let me for the time being skip the phrase due process and go straight to the digital times. Ladies and gentlemen, it is now. We are living in these times. Every day we hear of new applications of AI that would have made Isaac Asimov gasp. AI is already taking our jobs. However, I believe that as long as the honorable judges are not replaced by artificial intelligence, the members of the bar can still enjoy some job security. However, let us start with something a little simpler than artificial intelligence. Most of us gathered here have already replaced conventional passwords with fingerprint locks or facial recognition to protect the contents of our phones. Courts in the US, the so-called pioneers of due process, have held that the right to silence cannot be, or the right to silence really protects you from being forced to divulge your password. However, you can be compelled to place your finger on a scanner or show your face to achieve the same result, to divulge and expose the most intricate details of your digital life. This is due process in action, and yet the right against self-incrimination, which is the last bastion of life and liberty, evaporates with the swipe of a finger. And the digital state can go further. In the age of Aadhaar, when our biometric data is already canvassed and collected by the authorities, it is possible to 3D print a silicone mold of your fingerprint to unlock your device. This is not science fiction. This is in fact the digital age that we live in today. The problem, my learned friends, ladies and gentlemen, is that due process presupposes a procedure established by law, which is then to be tested against the anvil of our constitutional guarantees. against the trifecta of Articles 14, 19 and 21. But today, there is a legislative void. We are in the Wild West, ladies and gentlemen. How many of us really understand what cryptocurrency is or how it works? Our legislature doesn't understand it any better. They are playing catch-up. The knee-jerk reaction is always to try and ban these incumbent technologies as Luddites. However, the inexorable march of technology is a fait accompli. Yuval Noah Harari calls it the next step in our evolution. The proposition today believes that due process cannot operate in a vacuum where legislation is lagging behind and there is no procedure established by law. The deeper shortcoming is that due process is inherently reactive in nature, where we subject the harm already committed to judicial review. There is little scope for quatimate injunction where we barely understand the animal that we are dealing with. The right to be forgotten is recognized, but even after a takedown order is passed by court, trying to scrub the internet clean of content uploaded without authorization is impossible, particularly when this content is hosted on websites which are not amenable to our parochial laws. In the Boston Marathon bombing case, a subpoena was issued to WhatsApp to produce the chat records of the accused. WhatsApp refused, saying that their servers were located in Dublin and therefore not amenable to the jurisdiction of the courts. This case has inspired legislative change, and a lot of jurisdictions now require cloud storage servers to be present onshore. When your data is misused to train an AI model, no court can meaningfully order the system to unlearn what it has already observed. Remedy in damages is grossly inadequate. Therefore, the proposition believes that due process alone is not sufficient. Modern problems require modern solutions. You can regulate the speed of traffic by prosecuting or penalizing the violators of the speed limit, or you can place a speed bump which prevents the violation in the first place. This sort of digital right management technology has been used for a long time to combat piracy of copyrighted material, like the encryption on a CD which prevents the CD from being copied. We need inbuilt technological safety protocols which prevent the harm from occurring. It is not our stance that due process has to be defenestrated or thrown out the window. Bigyan manushke diyeche beg, kede niyeche abeg. Similarly, digital technology has accelerated decision making but has eroded accountability. In this climate, due process as we know it is due for change. And even then, due process alone is not enough to protect our rights from being infringed. We need a synergy between due process and technological safeguards built into emerging technologies to protect our constitutional freedoms. This is the stand of the proposition, and my fellow speakers shall establish this position further. Thank you.
Thank you, Ishan. Ishan paints a very, go ahead, I'm just talking about it. Ishan paints a very bleak picture of the Wild West that we find our technological development. Echoing all over the place, but the Wild West of the technological world we live in, where a lawless frontier of the internet exists and our data is not safe, our people are not safe, and God knows what can happen. And the law is merely playing catch-up. To counter such a picture, we have the first speaker of the opposition, Ujjoyini Chatterjee, who will present us with an alternative perspective.
यथा शास्त्रम विधिं कुर्यात् न च वेदेन चन्मित्रे शास्त्र विहितमेव कार्यम धर्मो हस्या प्रतिष्ठिता. Judgment delivered following the laws prescribed is the only way of achieving dharma. These are the words of the great Kautilya, recorded in the verses of Arthashastra. And with this thought in my mind, I welcome our honorable judges, learned seniors, my friends, ladies and gentlemen, to this evening of brainstorming whether the tenets of due process are indeed adequate to meet the challenges of a digital world. or otherwise. Due process of law is a term that was coined in the West, but has always been a part of our very own philosophy. It embodies the presence of fairness, of equal opportunity, and absence of arbitrariness, which is essential. Our Vedic tenets call it the only path of dharma. But these are words of the past, spoken by people who were not a part of today's world, where crime and criminal were both physically present and tangible, sometimes elusive, but mostly traceable. Today, we have created a world where we want everything at a lightning speed, and we have thus created a digital world, a world where everything is delivered in seconds. And just like the benefits that we reap of this world, even crimes are committed at a lightning speed, smirking at the traditional justice delivery system, telling us that you are slow, I'm much faster than you. The smart would suggest, why entangle ourselves in this complicated process of a due process of law? Why follow procedures? In case of a cybercrime, let me find a hacker. Let me find someone who can catch the criminal, and I can skip multiple processes in between, like registering an FIR, like identifying a suspect, like recording statements, like giving the suspect an opportunity of being heard and of defending himself. The hacker is going to identify one, and punishment will be imposed at the whims of the victim. Victim is rewarded. It is all satisfactory and hunky-dory, my friends, as long as the person charged with the crime and ultimately punished is not one of you. It is then that you will remember the words of the wise, the path of dharma, which, by following the due process of law, is the only way to ensure that there is lack of arbitrariness, that even the criminal is given an opportunity of defending oneself. To argue that due process is inadequate and to not suggest an alternative is really indicates the naivety of thought and the lack of understanding as to how human community has developed over the last 2000 years. But I am surprised at the suggestion given by my learned friends that this due process is inadequate. Law has been evolving with the inception of society, has it not? Has law remained static? Have we not undergone amendments? Do we not come up with a new law to tackle with a new mischief that comes up in society? And to do so, while doing so, it is incumbent upon the law agencies to ensure that fairness is there in the process. There is nothing done and there is nothing acceptable as long as we put an innocent behind the bars. To achieve the end by employing the wrong means will be always counterproductive. Yes, I agree, we belong to a generation where we want everything at a lightning speed, whether it is the research that we need for our matter next day or whether our expectations in a relationship. Everything has to be fast. However, justice delivery system, if hastened at this process, will always come at the cost of natural and personal rights, which is not desirable. Like my learned friend began his speech by saying, I will skip what due process means. I say that skipping will come at a cost of a lot of natural rights. And no matter how slow it is, I today remember the words of Gotham City's fierce protector saying, sometimes people deserve to be rewarded. People deserve to have their faith rewarded. But if we cross that line into killing, we are no different from the criminals we are fighting. It is the law that separates us from them. Thank you, ladies and gentlemen.
Thank you, Jenny, for giving us a stark reminder of what we would face if due process were not in place. But one wonders, with your quotation of Batman at the end, whether Batman himself followed any due process of law, because one would say that his style of vigilante justice is exactly contrary to the notion of due process. But that is also for something for our next speaker to consider. Our next speaker is Amani Kayan. She will be speaking for the motion. Amani, whenever you're ready.
My lords, my ladies, respected moderator, members of the bar, and my very supportive senior. Procedure is the handmaiden of justice, Yet today, a handmaiden trained for a paper world is expected to tame algorithms, deepfakes, and data brokers. The result is justice delayed, diluted, often denied. Today, I rise to argue that a classical conception of due process is structurally inadequate for the digital era. First, the speed and scale of state action online have outstripped due process safeguards. Section 69A of the Information Technology Act was framed when takedowns were rare, almost non-existent. Today, thousands of ex parte blocking orders silence speakers long before any hearing. Procedure that follows punishment is no procedure at all. Second, digital searches have turned constitutional protections into hollow guarantees. Investigators often copy entire phones or drives, sweeping through irrelevant private data. These digital general warrants violate the very principles of specificity and relevance that due process is built on. Third, algorithmic opacity defeats natural justice. Content moderation by machine learning models produces errors without reason, without accountability, and without a record for judicial review. If we cannot even identify the decision maker, how can we test its legality? Fourth, and according to me the most important, the cross-border nature of data flows renders domestic remedies ineffective. A post uploaded abroad, or let's say as far as the Arctics, can ruin reputations here in Calcutta. Yet mutual legal assistance treaties, drafted for letters, not live streams, move too slowly to offer real relief. I say that jurisdiction evaporates at the click of share. My friends may say that due process evolves, but evolution requires deliberate reform, statutory amendments, transparency mandates, enforceable treaties. What we have instead is executive discretion expanding unchecked, while courts and citizens remain powerless. You ask if I have a solution. Well, I have a suggestion. We need a change. We need a digital due process code, embedding algorithmic explainability, judicial warrants for device imaging with strict minimization, and time-bound platform disclosure subject to audits. We also need reciprocal data treaties so court orders travel by the byte. Justice Krishna Iyer once warned, procedure that spells delay is denial. In 2025, delay is measured in milliseconds and denial is coded into black box systems. Unless we re-engineer due process for this era, liberty will remain hostage to systems neither transparent nor accountable. Therefore, I urge this House to affirm that our inherited framework is indeed inadequate, and that recognizing this truth is the first step toward reform. Thank you. I now hand over the baton to my dearest friend, Sushriya Mitra.
I think it speaks about how digitally we have progressed so far forward that laws have struggling to keep up. Today, we find this example over and over again in our courts, when enforcement directorates come forward in cases and just seize devices willy-nilly without any regard as to whether those devices will actually yield something useful for investigation or not. And Amani rightly points out that unless we limit the access to the investigative agencies and the state, we might give up our liberty on a platter and demands that.
Good evening to my Lord and the Honorable President and the moderator and my peers here and my senior. It's an extremely fortunate moment for me. After hearing my other side speaking about this particular proposition, I would like to first state that let's understand what due process of law is in a very simpler form. Due process of law is fair procedures and substantial legal justice for individuals and for the society as large. As simple as that. All these legislative lacunas, frameworks, amendments which were all being proposed, those are not due process of law. Those are procedures established by law. So let's understand the difference first. Procedures established by law, which involves amendments, rules, regulations, procedures, these are all for addressing a specific issue of the society. These are sometimes beneficial for some people, sometimes disadvantageous. And obviously for the interpretation of it, we advocates play our role. While due process of law checks whether that law, that amendment, that rule, are those fair or arbitrary. And judiciary uses due process of law to ascertain the inadequacy of a procedure that is established by law, and that's how the concept of ultra vires came in being. Now, this is what due process of law is. Now, the proposition is due process of law is inadequate to meet the challenge of digital times. Now, let's go a step back and understand what was the situation before the digital times came in being. I drew the inspiration from the book authored by Justice A.K. And a chapter dealt with the prosecution of the officers of Mrs. Indira Gandhi and the creation of a special tribunal to try Mrs. Gandhi during the emergency. What happened that time? The officers were harassed by the winning party. They were arrested to spite Mrs. Gandhi. They were suspended and they were reinstated in their position after being defamed. This happens now even in digital times just by way of Instagram or Twitter. But again, now this decision was made because of political benefits, and an entire controversy was created among the common people that a malicious criminal proceeding was being done to the officers. What all of us missed out, and the author rightly pointed out, that harassment, defamation is separate. Let's see what happened to them. Under the service rules built on the foundation of due process of law, those suspended officers got allowance, and when they were cleared, the entire payment and their salary were given back to them. So you see, political controversy cannot be equated with due process of law, or inadequacy can't be found out from that. Because it was the due process of law that came to the rescue of the officers, because they were giving the opportunity to get heard, inquired, inspected, and the fear. Similar situation happened was when the idea of creating a special tribunal to try Mrs. Gandhi was formulated. And that was declared to be discriminatory under Article 14. Why? Because it was legally not feasible. It was the due process of law that stopped an abomination from being pronounced. So that is the due process of law. That is what happened before digital times. Now let's understand digital times. It is nothing different. It's basically what we were doing before, and now we are doing everything online at a much faster pace. From delivery of food in 10 minutes, to getting entertained by reels, from getting harassed by a click from the offender sitting behind the desk. All of these used to happen before. It is just now with the internet. How is due process of law inadequate? You see, for protection of personal rights, processing of personal data, privacy of a person, which is now recognized as a digital principle, all of these are being dealt by Digital Personal Data Protection Act. It was enacted by keeping in mind the due process of law. That is exactly why, for addressing the complaints and the problems, a data protection board was created. Now, if any provision in that particular act seems to be arbitrary, the adjudication will be done by what? By application of due process of law, fairness. Similarly, new act, it got agreed by got the agreement of the President, Promotion and Regulation of Online Gaming Act. It bans gambling, seizes phone, and the imposition of penalty. Well, you see, the act also follows due process of law, because the provisions in the act gives the power to investigate offences before the penalties are leveled, or powers to remove difficulties, which means inconsistency with due process of law. And thanks to my dearest friend who made a fantastic argument stating that jurisdiction gets evaporated, or penalties are being leveled. Nothing happens without reasoning. Nothing happens without due process of law. And thank you so much.
Very well spoken, Susriya. Susriya harks back to the point I was making prior to this debate starting, that what you speak of is procedure established by law, not necessarily due process of law. Due process of law being a much wider concept. And Susriya rightly points out that due process of law is what ensures that we get justice, that we get adequate protection against those who would intend otherwise. To counter this argument, we have Porush Bandopadhyay, who will be the last speaker for the motion. Porush, the podium is all yours.
Honorable judges, ladies and gentlemen, distinguished advocates, and my learned advocates still waiting for the honorable courts to take up matters so that due process of law can be enforced. I tell you why due process of law is inadequate by one example that Ms. Mitro came and quoted today. Ms. Mitro came and drew inspiration from a book that was launched today, not available to the public for the last 60 years. This is where due process of law has failed us. That access should not have been with Ms. Mitro. This is where there is failure of due process of law. This is where the digital times that we see today is not encapsulated by due process of law. Ms. Mitro the opposition comes and tells this honorable bench and the audience today that digital due process is a possibility and there is no change or departure from how due process of law started. I would urge everyone present in this room today to introspect for a moment. Introspect and see whether a cause that is being adjudicated upon by the set upon standards is not being defeated till such time the order is passed. If the cause does not stand defeated, or if it stands defeated, is the argument today. We are in a time where jurisdictional barriers are pinging from one country to another. A debtor seeks a creditor for 1 second in Africa, the next second in the Cayman Islands, the next second in the United States of America. Where do we expect to file this suit for recovery of money? My learned friends for side opposition comes and tells you that yes, you have a money decree. Yes, yes, you will be successful in enforcing this money decree against that judge insolvent. We, on behalf of the proposition, are not advocating against due process of law. We are advocating for the cause that due process of law requires evolvement with the digital times, needs to tackle a situation where data can be disseminated through seconds throughout countries and be downloaded on 1,000 different devices and be further shared. We are not against the established principles of due process of law. We are telling this honorable room today that due process of law is ineffective in the digital times because the due process of law assumes that standards that are to be followed are time-taking and require adjudication upon on the basis of established principles of law. It is our objective before this august room to suggest a situation where due process of law would be adequate to the digital times. If we say that due process of law is adequate to the digital times, we are trying to catch a shark with, if I say so, with a moshari. This is not possible in today's day and age. We urge this honorable room, when this motion is put to vote, to introspect as to whether actually due process of law can be enforced in the digital times on the ground roots of the reality that digital data dissemination is beyond captivation or understanding of what and how due process of law can be enforced. With that, may I conclude my arguments for side proposition today and urge you that when this motion is put to vote, this House votes that the motion stands.
Thank you, Porush. Porush very passionately said that due process of law is not what we are against for the motion, but we are saying it is inadequate. It has evolved much to challenge the times that we face today, and that it needs to evolve, and we need to come up with better protections in this modern era. Otherwise, we will have a situation where we will not have adequate mechanism to catch the injustices of today. And to counter that and to rest the argument against the motion, we have Shobhadip Banerjee. Shobhadip Banerjee, podium is all yours.
Due process of law. This is a concept that has been evolved from the Magna Carta, which is the Royal Charter of Rights as early as the 13th century. Now, when we talk about due process of law, it's just not about the substantive legislation is in place. It deals with two aspects. The first being substantial due process, which identifies the right in itself, and secondly, the procedural due process, which identifies the safeguard as to how the rights could be protected. Now, coming to the digital age aspect. Now, rule of law cannot be defeated by the advancement of digital age. And the first point that I want to illustrate, as has been stated by Lord Denning, let ye be ever so high that the law is higher than ye. This would mean the supremacy of the law. All procedures established under law and the people who are subject to the law are all secondary. The supremacy is to the law in itself. Now, moving on, how has law evolved in India in regard to the digital age? Now, digital age, the first major legislation that has come in India is the Information Technology Act, which was enacted in 2000. Now, Digital Technology Act provides us with several safeguards as to how encrypted data can be used and protected. However, the judgment of Puttaswamy, the 9-bench constitutional bench, highlighted the right to privacy as a constitutional right, which led to the enactment of, more recently in 2023, it led to the enactment Digital Personal Data Protection Act of 2023. And further, the law is progressing to facilitate the artificial intelligence and cloud computing and other aspects which are not covered by the Information Technology Act. We would be having a Digital India Act, which is a work in progress. Now, coming back to the arguments that have been advanced, it shall be my endeavor to show how baseless the arguments is. One of the arguments that was advanced is due process presupposes procedure under law. When we are talking about due process, it's our constitutional mandate. It's the substantive law, it's the law of the land. We cannot dissect it to an aspect of digital age. There would be legislations. Every legislation keeps on evolving, as has been pointed out. There would be amendments to a legislation. When a legislation is no more effective, we have a new enactment that comes up. But that does not defeat the very cardinal principle, which is due process of law, which ensures that fairness and reasonableness is observed by all individuals of the society. Mr. Bandopadhyay, my learned opponent, has also raised a question that Ms. Mitra had cited example from the book which has been launched today. Perhaps the book is available online. Mr. Bandopadhyay does not know how to download the book, but still he goes on to mention that the digital law prevailing in our country is inadequate. Now, moving on, it has also been argued that there is a legislative void. Legislative void cannot be equated with defeating the process of the rule of law, as has been observed by Lord Neuberger when he was sitting extrajudicially, that has been, my apologies, as has been observed, no system involving people will ever be perfect or perpetual. But without rule of law, democratic government is a hollow thing. That is the main emphasis that I am trying to highlight before this House. That when we are talking about due process, it's just not about the legislation itself, it is also about the procedure which will ensure fairness amongst the people. That's why our constitution mandate is, it is for the people and it is by the people. When we are talking about the evolution that's happened and the process evolved by the rule of law, there has been decisions. The first major decision that has come into place is the decision of Keshwananda Bharati, which emphasizes that there has to be observance of supremacy to the constitution while making a decision on whether a constitutional amendment is valid or not. Today, when we are looking at the substantive law itself, there could be some lack in the law, but that is because the time is evolving. With time and age, the law will also evolve. But the cardinal principle of rule of law or due observance of law continuing the fact that law is supreme above all individuals, no matter who they are, will remain at the very centrifugal of things. Thank you, ladies and gentlemen.
Thank you, Shorodip, for not going too past the time limit and curbing yourself. One thing Shorodip has proved is that regardless of whether due process of law has caught up to our digital times, all the speakers here today have shown that they have definitely caught up to the digital times, as they have each relied on their iPads extensively to present their arguments. And it just goes to show that we are evolving as lawyers, and I would believe the court is not very far behind, because I do not think an Anton Pillar injunction would have been conceived of in the last century unless our judges had evolved themselves. That today they recognize the challenges of the digital times, and thus something like an Anton Pillar injunction has been devised by our courts to try and keep up with these modern times. But regardless of what I think of the matter, and regardless of what the speakers think of the matter, what matters is what you think as members of the audience. And thus, I put it to the vote. If you think that due process of law is inadequate in meeting the challenges of the digital times, and thus you agree with the side proposing the motion, please raise your hands. We have a few hands raised, but the real challenge is to see whether, if you support those speaking against the motion, please raise your hands. I think the nays have it today. And with that, the motion has been defeated, and against the motion wins today. Thank you very much. I hand over the proceedings to the Honorable Secretary.
Thank you, Mr. Chakraborty. Thank you to the speakers for the lovely, short, enthralling debate. We are all in due process of getting ourselves updated to the digital times. But before I invite Justice Sujoy Paul for what has been a Passover speech, which was kept reserved, may I take the opportunity of honoring our speakers and also honoring another member of our library. So, since the debate just ended, may I invite first the moderator to come in front of Justice Pal, and as a memento, we gift a book that was unveiled today to each of the speakers. Mr. Shayok Chakraborty for moderating the debate. Can we have the members of the proposition, led by their captain, Mr. Ishan Shah, followed by Ms. Amani Kayan, and thereafter Mr. Pourush Bandopadhyay, to accept the book as a memento from Justice Paul. And now can we have the opposition team led by the captain, Ms. Ujjoyini Chatterjee, Ms. Sushreya Mitro, and last but not the least, Mr. Shorodip Banerjee. A small felicitation still left before I invite Justice Sujoy Paul to deliver his speech. One of our members, and we are very proud to announce this, Mr. Somnath Ganguly, has been appointed as a judicial member of the GST Appellate Tribunal. I don't think Many of our members are aware of this, and I take this opportunity and the presence of Justice Paul to honor Mr. Ganguly. May I call upon Mr. Somnath Ganguly to please come up here and collect a small memento from Justice Paul as a token of gratitude of the Bar Library Club, and we are very proud of your achievement, and may you hold the flag of our club high in discharging your judicial functions as well. Now I have the privilege of inviting our chief guest, Justice Sujoy Paul, to the podium to say a few words.
My esteemed brother and sister judges present in the auditorium, the office bearers of the three wings of the association, the young lawyers, the members of the bar, ladies and gentlemen, respected family members of Justice Das, it's my privilege that I am part of an event in this club which is older than the High Court itself. We have assembled here for this event on the weekend, after a hectic weekend, and therefore I would like to start with a lighter note. I remember when I was given the charge of the Director, National Judicial Academy, for about more than 8 months when I was judge of my parent High Court, Madhya Pradesh High Court. So there were sessions on Saturdays and Sundays for High Court judges and for the judges of district judiciary. The second day, which was end of the week, and judges travelled after their judicial duties from all corners of the country. So I overheard a conversation between two participants, and they said that last session of last day can be safely called as a graveyard session. I don't want to make this session, which is at the end of the week, more grave than graveyard. And therefore I started with this lighter note and with a joke which has some nexus with today's subject. And it goes like that a young woman in Paris went to a garment shop to buy the latest gown as per the fashion which is prevailing. By the time she selected the gown and came out, the fashion changed. And in our digital world, perhaps the change is faster than the fashion of Paris. And that change is naturally posing very important questions before us. One of the participants faintly mentioned about a book written by Yuval Noah Harari. And I'll suggest all the avid readers to please go through that book, which is a wonderful creation of this century, I'll say. The author has written very important books, Homo sapiens, Homo Deus, and then he came up with the book 21 Lessons for 21st Century. Although a next book called Nexus has also come in the market by the same author. The 21 Lessons for 21st Century talks about the challenges which the digital world or the AI is posing before the entire humanity. And every lesson which is divided, the challenge to the humanity, challenge to the religion, challenge to the justice system, challenge to the nationalism, challenge to the society. And in a very lucid words, he has explained how these challenges are. And in the same National Judicial Academy, we had a session with the British judges. First day, the British judges were required to submit, share their experiences, and second day it was followed by our judges, Indian judges. The one real experience which may be food for thought for all of us, I would like to share with you. And that experience which, the incident which happened actually in UK, that a young minor girl, while on the web, entered the dark web. And in the dark web, she was gang raped virtually. Now the question before the society and particularly before the legal fraternity is that there is no physical touch, there is no physical harm. But the psychological impact is exactly the same. The trauma which that young girl has faced is exactly the same. Nobody knows accused are from which country. Then the law is insufficient, which will be the jurisdiction who will trace how those accused persons can be traced. All these are the conundrum which the society is facing. Likewise, various delegates raised questions, and many of us, those who are tech savvy, they also didn't have the answer. So we are in a world which is changing very rapidly, and it is posing new challenges. By the time we are meeting challenges, a new challenge again comes. When I was posted in Telangana High Court in Hyderabad, one day I got a fake call saying that your bank account is used for anti-national activities, and this is a call from RBI. I immediately reported that incident to the cyber crime section of the police. And police after some time informed us that the call was from a homemaker who is stationed at Rai Bareli in Uttar Pradesh, and her phone was hacked by somebody and used from Denmark. Now the question is how to deal with this kind of situation. These are all new questions every day emerging. By the time we are debating, by the time we are thinking how to crack it, a new question, a new technology, a new method to break it is coming up. Another food for thought and a unique method adopted by a police commissioner I must share with you, that police wanted to prepare some software for the use of public, but their worry was that it shouldn't be hacked by somebody, and therefore they employed the best of the technocrats or the specialists so that all kinds of firewalls can be put. And when they got a certificate, now it cannot be cracked. The unique idea of the police commissioner was that he decided to invite all the public at large for a hackathon, not marathon, it is hackathon, that anybody can come and crack it. If somebody cracks it, he will get a prize. And you will not believe that 10th failed students cracked it. And they were, because of that, police came to know that how to protect, where is the leakage, where is the shortage. So we are in that era where privacy itself is under stake. I remember that one of the participants said that yesterday I was in my office and I was discussing with my personal secretary that in some books of my library there are termite. And after 2 hours, I started receiving WhatsApp message and advertisements about how to cure termite. This is the situation about our privacy. So these are the challenges before the society, and the eminent speakers very rightly said that due process of law is not a fixed idea, or it's not in the word coined for constitution by Palkiwala, it's not like jellyfish. Due process of law is also evolving every day, but there is a challenge which is always bigger than the due process of law which is in place. And therefore all of us, those who are in the legal field, as a human being, as a part of the society, we have to face these challenges because the things are happening in a very, very fast mode. So these were my wild thoughts. I was not for or against the motion, and after my completion of my judicial work, I am not required to be judgmental anymore. and therefore these were the food of thought as from a student of law. Thank you so much for the organizers for calling me and giving me this opportunity to interact with you. Thank you so much.
Thank you, Justice Paul, for giving us a glimpse of an evening in Paris and for establishing that we have another Harari fan amongst us. Now, ladies and gentlemen, we have almost come to the end of today's program. Before we part, I must just read one passage from a letter written by Justice Dipankar Dotto to the family member of Justice A.K. Das regarding the book. I was supposed to read it at the opening statement of mine, but somehow it got skipped. Just one paragraph. It's a personal letter, so I won't trouble you with the other portion, but just one paragraph about the book. Justice Das brings a sharp eye to both the strengths and shortcomings of India's constitutional systems. His essays are rich with contemporary examples exploring critical themes such as the presidential versus Westminster forms of government, judicial independence, the tensions between the parliament and judiciary, and the power of privilege in legislative affairs. Particularly compelling is his perspective on one of the most troubling chapters in India's constitutional history, the emergency. I skip over a few paragraphs and come to another. Few judges write beyond judgments, and fewer still write with such candor and conviction. As judges, we are often constrained by the need to speak only to the matters before us. Articles like these, however, offer the freedom to engage more broadly, to reflect on the law, not just in theory, but in the context of ground realities. So, ladies and gentlemen, we have the book in the library and the members can peruse the same. Now, to deliver a formal vote of thanks, I must of course thank all of you that in a Friday evening, notwithstanding the weather, notwithstanding the tragic incident and the news that we all faced in the morning, all of you have been present here and we have a full house. But to deliver the formal vote of thanks, may I call upon Ms. Shananda Mukhopadhyay, our committee member.
On behalf of the Calcutta Bar Library Club and the committee, I extend my deep regards and sincere gratitude to our Chief Guest, Honorable Justice Sujoy Pal, as well as other honorable judges for gracing this event. I equally thank the learned and valuable members of the Bar, the Incorporated Law Society, and the Bar Association. I thank my dear beloved colleagues of Bar Library Club for being present today. This book, Due Process of Law, written by Justice Arun Kumar Das some 4 decades ago, still finds relevance today. It gives us many precious and interesting information and on a wide range of socio-political happenings which are perhaps still being discussed at various levels and still influencing the society at large. In that regard, I thank Srimati Midula Nandi, Srimati Sonia Roy, and Shinjini, and other dear family members and friends for their unending love and affection and enthusiasm which has given this book a new life. I must mention Mrs. Shanjukta Gupta, Mr. Noyanchan Bihani for going out of their way in organizing and arranging a very delectable high tea for all the guests present here. I congratulate all the participants for such an invigorating debate, particularly the high quality of it on your reasoning and clarity of vision. Thank you once more. Last but not the least, my own committee members, they have been going out of their way and putting in all the extra efforts and hours and arduously and painstakingly organizing such events for all of us to enjoy and witness. Thank you all.
We formally come to the end of today's program. May I request our members to have their seat. I first request the dignitaries on the podium to please come to the next room and have some refreshments. Then we'll request the guests there to follow suit. And 5 or 6 minutes later, we will request our members also so that we can, yes. May I request the honorable judges also to please follow, please. Please, sir, you can just help yourself and you can come back to this room so that that room doesn't get unnecessarily crowded.